and his siblings.
The wife and his siblings. The reason I'm asking this question is because my brother was in a credit union, and the credit union gave the wife all the monies, whereas my mother was supposed to be, actually, she was his beneficiary along with the wife, but she predeceased him.
Oh, okay.
But the credit union gave all the money to the wife. I want to know, did they do the right thing?
Technically, yes. Technically, yes. They can't give everything to the wife in a situation like that. No matter.
Because they say that a dead person cannot inherit.
No, they're right. A dead person certainly cannot inherit. So your mother's share would have what is called in law lapsed, right? So so your mother has nothing in a sense. So if there is only a wife or a spouse, then the spouse inherits. But if there is, I just need to check it to be absolutely sure.
All right, well, I think this is something that perhaps, as I said, we will give Veronica's number at the end of the program. So perhaps, caller, you can call her and then she can give you that. Can you be very brief because we're running out of time?
One brief question. Also in that same situation, he had property before he was married to the wife. Who inherits that property?
If it is part of the estate, if it is part of his estate, his wife inherits it as well. In the same conditions, she has to decide to give up her share in the community and take the property.
Okay, and am I right in saying, Veronica, that if the brother had made a will actually naming specific people, then those specific people would have got specific things from his estate?
Absolutely. And if your brother had nieces and nephews, it also complicates the situation as well.
Nieces and nephews, without brothers and sisters?
Just brothers and sisters? Okay. Well, it's not a simple answer, so perhaps we need to follow up after.
All right. Thank you very much, caller. Let's quickly try and answer the question that I asked initially. What about an illegitimate child who was born before the father got married? Would they be able to inherit? Andrea?
No, they would not be able to inherit based on the definition of what a single man is in the legislation. It says that a single man is a man who has never been married. And the fact that that one has been married, the child is illegitimate, the child is not going to inherit.
Okay, let me go through another question. When I was a child, I had my mom's last name, so my dad had it changed, and now I have a deed poll to carry around. I don't think that he has a will. If he were to marry his present girlfriend and have kids and happens to pass away, he says that the deed poll stands like a will and still entitles me to my share of whatever he has in case he has children in the marriage. Can I have some clarification on this?
I'm sorry to tell the person asking the question, absolutely not. A deed poll is simply what it is. It's a change of name. And if it was a deed poll and not even an acknowledgement of paternity, it also doesn't say that your father, you participate in your father's life at all. He recognizes you as his child if he was not the one who actually did the deed poll himself. A deed poll cannot stand in the face of a will, and because in St. Lucia the definition of single man, he would not be entitled at all. He's out totally.
Okay. Here we are from Dawn. The law of succession is a topic for all the advocates out there to pounce on. The question always remains: why have these laws have not been changed? Men in the House of Parliament. Something from Oliver. Law of successions as it relates to wills, etc., are too frustrating, time-consuming and complex, like legal divorce or separation. The whole process needs to be simplified, as it is now a cash cow for the legal personnel. Why in 2012 a so-called illegitimate child cannot be a beneficiary of his parents' possession, but claims can be made for that child's support? And he goes on. We're going to put these comments online. Okay, let's go back to the phones. This is going to be the last call tonight. Welcome to Dolor Factor Live. Thank you for calling.
Thank you. Good night, Julia and your guests. It's a very interesting program.
Good night.
I just have two questions. My daughter is only 6 years old. My life insurance is on my mother's name. I know that has implication, but what can I do?
You can appoint your mother as her guardian. So you put it on her name, on your daughter's name with your mother as what is called a tutor under our law, in representing the interests of your daughter. So
Okay.
if anything happens to you, your mother holds it, but for the benefit of your daughter.
Okay, my second question, I'm actually planning to get my will, but I have told her father, because we're not married, I'm single, that I would like to appoint somebody to care for my daughter, and he said he doesn't agree. So I know in St. Louis, if you're not married, you're your child's legal guardian. So I will listen to your answer off the.
Okay. Off air. Oh, she
Okay.
listen now.
All right. Yes.
Yes. Okay. Yes. As a single mother, she is a legal guardian of her daughter. Unfortunately, the father doesn't have much say in that regard, so she can appoint somebody in the event of her death to be a guardian of the child. She can do it by will, and she can also do it by something called a deed of appointment of tutor. So not necessarily by a will. There is a notarial document that you can actually have done. So in the event of your death, you state who you want to leave the responsibility of your child to.
Okay.
It can also be incorporated in the will.
Yes.
Okay,
Yeah.
thank you for that. Here's something from Victor Reed. Are there forms that can be prepared or used by people with all the necessary security features to allow us the option of preparing our own wills and have them registered as legal? I think, Andrea,
Well,
can
in
you
the
answer
first
that?
place, yes, we said I indicated that an individual can prepare a will, what is referred to as a holograph will. It has to be in your hand, in the person's handwriting, and it does not necessarily have to be witnessed at the time when it is prepared. So
Except-
yes, you can prepare your own will.
But there really are no forms, and the reason why that the question is that because the law is so complicated, it is always better. There are many questions that need to be asked, and then the attorney will determine what are some of the provisions that need to be put in. I suppose somebody can undertake that as a project. We don't have legal aid, but that's a good project that can be undertaken. But so far, no.
Okay, we're going to go to a really quick break and come back with a very short segment. So if you haven't asked your question, you can ask your question, you can email them. They will be answered. Maybe not live, but they will be answered. This is Dolor Factor Live on DBS. See you soon.